Hello, welcome back. We continue with section 103. 103 talks about notice etc. to or by persons incompetent to contract. Who are the people who are incompetent to contract? Anyone? We must be knowing about it, right? We know Contract Act. So anyone who is minor in age, anyone who is of unsound mind, anyone who is insolvent or otherwise prohibited by law for the time being in force, anyone who is insolvent, who are all those otherwise prohibited by law for the time being in force? Convict, aliens, enemies. Am I right? So all these people are all incompetent to contract. So when they are all incompetent to enter into a contract, notice, they cannot send a notice, they cannot receive a notice as well. So who will receive the notice on behalf of them? You are right, guardian. What sort of a guardian? Legally appointed guardian or naturally appointed guardian. Okay? So when the suit goes to the court may appoint a guardian if there is no other guardians. Okay? So it is for the guardian to accept or to send notice when there is any suit. Clear? That is 103. Then we go to 104. Power to make rules. Of course, this is a general provision. Who has the power to make rules? The High Court of every state has the power to make rules. Okay. Then next we go to chapter 5 of leases of immovable property. We know lease. Am I right? Definition of lease. Section 105. Definition of lease. A lease of immovable property is a transfer of a right. It's a transfer of a right to enjoy the property made for a certain time, express or implied or in perpetuity, in consideration of a price paid or promised, or of money, a share of crops, service or any other thing of value, to be rendered periodically or to specified occasions to the transferor by the transferee who accepts the transfer on such terms. So when we are talking about lease, definition of lease, what should we talk about? We are talking about the transfer of a right to enjoy a property. To enjoy a property when? For a particular period of time. Okay? Particular period of time. And for a particular consideration. When we do in Contract Act, we know that consideration can be monetary or non-monetary. Am I right? Here we are seeing it very blatantly. Here the law says either it can be for money or for crops or service or any other thing. Now when it is for money, we know that it is for monetary, right? But when we are talking about crops, service or any other thing like that, any other goods, items, okay? In that case, it becomes non-monetary. So if it is like this, you have a valid contract. Okay, so what is a lease? This is the lease. These are the main ingredients of a lease. Lessor, lessee, premium and rent defined. Who is the lessor? The one who transfers the right. Who transfers the right to enjoy is known as lessor. To whom it is transferred. Who transfers is known as lessor. to whom it is transferred is known as lessee. What is the premium? The premium is the price paid for the, we saw here, consideration. It is the consideration which is paid for the lease. And rent. Rent is what? It is the price paid. That is when we are giving the advance amount, the premium amount. The advance amount, not the advance amount. What is it called? The lease amount. It is known as price. Okay, and the rent. Rent is what happens in regular basis. If it is a monthly rent, then that shall be given. If it is a fortnightly rent, which never happens of course, then it will be given, okay, at regular intervals. That is known as rent. We go on to the next section, 106. Duration of certain leases in absence of written contract or local usage. Where there is a written contract, the lease is for such a period, right? But where there is no written contract, then what shall be the period of lease? What shall be the period of lease? It shall be as per the written contract or as per the local usage. In the absence of a contract or local law or usage, to the contrary, lease of immovable property for agricultural or manufacturing purposes shall be deemed to be a lease from year to year, terminable on the part of either party by 6 months notice. Where it relates to agriculture or manufacture, it shall be on annual basis. The lease shall be on annual basis and it shall be renewed upon 6 months notice. If I am running a manufacturing factory, then I will have to give the 6 months notice if I have to vacate by this year end. Ending of the year of the rental agreement, the lease agreement. Okay, terminable on part of the either party by 6 months notice, and a lease of immovable property for any other purpose shall be deemed to be for a lease from month to month, terminable on the part of either party by 15 days notice. Okay, so from month to month. That's why when we write the rental agreement or rental agreement for a residential property, we don't say 1 year. How do we mention? 11 months, 12 months. This is how we mention. 36 months. Am I right? So we don't mention the years there. Why do we do it? That is only because of this. Then number 2, notwithstanding anything contained in any other law, the period shall commence from the date of receipt of notice. What period? For the vacating of the premises. For vacating the premises, if I am serving a notice to the owner, then the date for such thing will start from date of receipt of notice. If I am sending a date saying that it is 11 September and the owner receives it on 15 September, then my time starts on 15 September. Okay? A notice under subsection 1 shall not be deemed to be invalid merely because the mentioned period therein falls short of the period specified under that subsection, where a suit or proceeding is filed after the expiry of period mentioned in that subsection. In this thing, what is the period? 6 months, 15 days. Okay, so just because there was only 3 months notice, this notice shall not be held as invalid. This notice shall not be held as invalid just because it's a 3 months. Here it says renewed at least 6 months. Notice should be given. Okay, 6 months notice should be given. Here what is given? 15 days notice. But just because 3 months notice was given, that doesn't make the notice as invalid. Even then it is valid. That's why when we write the again and again, we take the example of what we do in practice. Am I right? So when we are writing, we say that 1 month receipt, 1 month notice should be given. 2 months notice should be given for vacating the premises. This is how we write. Why? Because the law itself allows 1 week notice. Each time we do one thing, right? Every notice under subsection 1 must be in writing, signed by or on behalf of the person giving it, and either be sent by post to the party who is intended to be bound by it, or be tendered or delivered personally to such party. So you know what it is, to family or servants at his residence. Okay, so it can be sent in any manner. It can either be by post or by personal delivery. Okay, it can be either sent by post or it can be personally delivered. To whom can it be personally delivered? Either to the party himself, or his agent. When we say agent, here it includes his family or servant at his residence. What's the third type? Post, personal delivery, affixture. In a very viewable place where everybody can see what is there. So the affixture can be in some conspicuous place. So it can be by post, by personal delivery, or by affixture, either to the party or his agent. His agent can be either any of his family members or servant at his residence. Okay. When we say servant at his residence, see, in CPC when we go to see, we see that servants are debarred from receiving the notice. If I serve a notice to the servant of the house under CPC, it will not be held to be valid, right? But when it comes to this under Transfer of Property Act, this particular section, servants are also allowed. Leases, how made? We go to the next section, section 107. Section 107, leases, how made? A lease of immovable property from year to year or for any term exceeding 1 year or reserving a yearly rent can be made only by a registered instrument. So how can a lease be made? By a registered instrument. All other leases of immovable property may be made either by a registered instrument or oral agreement accompanied by delivery of possession. So where it is 1 year or more, it should be a registered instrument. But where it is for any other period, then it can either be a registered instrument or oral agreement. If it is oral agreement or if it is registered agreement, transfer of possession is important. Understand, whether it is by registered instrument or oral instrument, transfer of possession is important. Where a lease of immovable property is made by a registered instrument, such instrument, or where there are more than one instrument, each such instrument shall be executed by the lessor and the lessee. See, for example, if there are 3 floors, okay, and all the 3 floors need, suppose it needs separate agreements, or say there are 3 different buildings, belonging to the same owner. Okay, but it will require more better example than this is this. It requires separate lease agreements. Am I right? So in that case, separate lease agreement shall be entered into, and it shall be signed both by the lessor as well as the lessee. Provided that the state government may from time to time change the rules relating to this particular section. Okay, we go on to the next section, 108, I'm sorry. That speaks about the rights and liabilities of the lessor and lessee. First we speak about the rights and liabilities of the lessor. The lessor is bound to disclose to the lessee any material defect in the property with reference to its intended use, of which the former is and the latter is not aware, and which latter could not with ordinary care discover. Are you reminded of anything when we read this paragraph? Yes, we read it just before the mortgager and the mortgagee. Am I right? So same way, lessor should also disclose. So what is his first duty? He should disclose any material defects. There is no, see, in the case of mortgager and mortgagee, material defects and title. Am I right? But here it is only material defects in the property. See, that also when we say defects, it is not necessary. If there is a garden outside the house and the lessor did not say that the garden doesn't have a plant, it doesn't have any plants, it's just a plain ground. How is it going to affect the lessee in any manner? It's not going to affect the lessee in any manner. So what he should disclose? Material defects with regard to the use of the property by the lessee. Understand? There is a big house or small house, whatever. There is a garden outside, there are no plants in the garden. And then the lessee cannot say, oh my God, you didn't tell me that there are no plants in the garden. Is it necessary for use of the house? No. Right? So, disclose the material defects for the use of the lessee. The lessor is bound on the lessee's request to put him in possession. Lessor has to put the lessee in possession unless the lessee says, no, I'll come after 15 days, I can't shift now. Third, the lessor shall be deemed to contract with the lessee that if the latter pays the rent reserved by the lease and performs the contracts, then he may hold the property during the time limited by the lease without interruption. So if all the dues which have to be paid by the lessee are being paid properly, then the lessor cannot interfere and put him out of the house. Understand? He has to allow him to stay back in the house or building or whatever and use the property. Rights and liabilities of the lessee. In it, during the continuance of the lease, if during the continuance of the lease any accession is made to the property, such accession shall be deemed to be comprised in the lease. See, for example, there is a house, there is a building. Okay, in this building, say probably this is what covers the lease agreement. But after a few days or few months, this part also becomes vacant. Okay, provided it is all in the same thing. If it is done by a separation, then it is separate. But if it is in the same building, but this has been occupied, then it shall be deemed to be a part of the lease property. Okay, so any accession which is made during the lease shall be deemed to be as if this property also is covered under lease. If by fire, tempest or flood or violence of an army or mob or other irresistible force, any material part of the property be wholly destroyed or rendered substantially and permanently unfit, the lessee may at the option, the lease may at the option of the lessee be void. See again here what you have to see, the loss which is being made is by a law, is by an act otherwise than by the lessee. It is not the lessee's negligence. Understand? So it is a act which is by beyond the control of the lessee. Beyond the control of the lessee. Understand? So see, here they have given fire, tempest, and then flood or violence by mob or by army or whatever. These are all situations which are beyond the control of the lessee. Am I right? So if at all there is any permanent or substantial damage, or if it has been completely destroyed, whatever is the situation there, the lease may be deemed to have been void if the lessee feels so. If the lessee says, no, I don't want to stay in such a house, I am leaving it, then the lessor cannot say, no, still 4 months are left in the lease agreement, so you should stay back for the 4 months. No. At the option of the lessee, the lease shall become void, provided that if the inquiry be occasioned by the wrongful act or default of the lessee. See, if the fire has been caused because the lessee lit one cigarette near the gas stove, okay, in that case, the lessee shall be held liable for the destruction. Understand? So, it should not be because of any default by the lessee. If the lessor neglects to make within a reasonable time after notice any repairs he is bound to make to the property, the lessee may make the same himself and deduct the expense of such repairs. See, if there are any repairs to be made by it is required in the property, then the lessee can make the, see, it is the lessor's duty to do everything. But if the lessor doesn't repair, then the lessee can repair the property and then cut the expenses, deduct the expenses from the amount. If the lessor neglects to make any payment which he is bound to make and which if not made by him is recoverable from the lessee, the lessee may make such payment. First one we saw was repairs. Second one, if any amount is due from the lessor to some third party, okay, maybe public authority also. But if the lessor doesn't make such repayment, such payment, and therefore the lessee is made to make the payment, in such case the lessee shall deduct the amount from the rent which is payable. The lessee may, even after determination of the lease, remove at any time all things which he has attached to the earth, provided he leaves the property in the state in which he received it. Understand? So whatever additional things that he has done, whatever additional things that the lessee has done to the, not to the building, to the to the building or where he is staying or the room or something like that, he has the right to take back everything and then leave the property. Okay, next one. When a lease of uncertain duration determines by any means except the fault of the lessee, he or his legal representative is entitled to all the crops planted or sown by the lessee and growing upon the property when the lease determines. Understand? So, here what we saw was, even after the lease gets over, he can take back all the properties that he has, all the items or whatever additions he has made to the property, right, even after the lease gets over. Same way, if it is regarding any uncertain lease period, usually all these lands and all that, if there is an uncertain lease period, then what happens? The person, the lessee, who has sown or who has grown, it can be anything, am I right? Who has sown or grown the crops has the right to ingress and egress. He can come inside and go outside. He can come inside and go outside. The leased property, which is already over, the lease is over, but he has the right to come inside, take the crops, whatever he has sown, and he can go back. Okay? Even after the lease period is over. We will stop with this and we'll continue with the same section in the next session. Okay? Thank you.